Okay, so next we have is right to constitutional remedy. Because we have like 5 different types of writs over here, maybe we will continue this in the next class. Just we will see what is the provision all about. So right to constitutional remedy is nothing but the 6th or the last category of fundamental rights, wherein it guarantees that whatever fundamental rights are given to us, we will for sure be able to enjoy them. Okay, and in case these are violated, we can directly approach the Supreme Court of India. So it talks about right to move Supreme Court by appropriate proceeding for enforcement of these rights. In order to enforce it, we can directly move to Supreme Court of India. So how do we proceed? How do we move to the Supreme Court? By way of 5 different types of writs. So Supreme Court shall have the power to issue directions or orders or writs, which would include all these 5 different types. Okay, so when we talk about writs, they are nothing but orders or directions of the court. Court is having the power to pass an order or to give some directions. All right, so this is nothing but what writ is all about, and we have 5 different types for this. Now, these will be different based on what is the situation or what is the reason why you are approaching the court basically. First one is habeas corpus. Now, if you remember these words, it would be enough for you to recall what this certain writ is. Habeas corpus, which means to have the body. So this writ will be issued if a person is wrongfully arrested or wrongfully detained. Okay, in such cases, this writ may be issued. Like take for example, when a person is arrested, he should be produced before the magistrate within 24 hours. But if he is not produced before magistrate, he is simply kept in the lockup. In such cases, this writ may be issued that to have the body. Court will ask that produce this so-and-so person in front of us, and we will see whether his ground of arrest is lawful or not, whether it is satisfactory or not. If it is not satisfactory, court may even pass an order that release this person. There is no valid enough ground for his arrest. Okay, so first one is habeas corpus, to have the body. Second one is mandamus, which means to command. Now this writ is very important because India is a welfare country, right? Government tries to provide bring a lot of welfare schemes and a lot of provisions. Okay, so because India is a welfare state and there are a lot of government schemes and everything, who will ultimately implement them? Whatever government schemes are there, it will be some government department who would be assigned the job that you need to do this certain thing for people to be able to enjoy the benefits, right? So it's very much needed that all the authorities who are there in different government bodies, they perform their job properly. All right, so what is mandamus? It is nothing but if the executive body fails to perform or violates any constitutionally mandated duty, a writ of mandamus can be filed. So might be government has said that if someone is applying for a passport, all the documents are submitted and everything, it needs to be given to the person maybe within a month. Now, if there are some authorities in the government, might be the police officer who comes for verification, police officer is like, you need to pay me extra, otherwise I'm not going to get your verification done. In such a case, it is nothing but mandamus, right? That you can see, you can go to the court and say, I have applied for passport, all the documents, everything is clear, but I'm not getting it. That means some authority is not performing their job properly. That's how you are suffering loss. That's how your rights are being violated. Same ways, if you have applied for a driving license, RTO officer needs to provide you that. But if it is not done, it's nothing but you can approach the court by way of mandamus. Same ways you would see, are you aware of that Narendra Modi's RTI thing? His qualification was asked by way of an RTI application.
Yes, ma'am.
Right, but then information was not provided. On the other hand, it led to changes or completely amendment in the RTI Act in itself. Right, Delhi University just said that yes, he has completed this part-time course from us, but then this detailed list and other things which were asked, those were not provided. So in such a case, if information has not been provided by a public authority, there also we can file this writ that I was seeking this information, it was not been provided. Right, there may be different boards for electricity, water, other things, right? Take for example, BWSSB is sending some wrong bills, or maybe Delhi Jal Board is sending some wrong bills of a higher amount. You are seeking the reasons, you are seeking for the breakup and stuff, they are not providing. There also you can file this writ that this certain government authority is not performing their job properly, not fulfilling their duty. As a result, I am suffering loss. Okay, so mandamus is nothing but to command that you have this obligation, you need to perform it also. Then prohibition and certiorari are related to each other, as in they are related to courts, okay, but in two different situations. Prohibition means to prevent or to stop. Okay, so take for example, there is a subordinate court, a case is filed before them. Now we have a concept of jurisdiction, right? Whether it is the right court to try this matter or not. Maybe this subordinate court is not having jurisdiction to try a certain case, but still by mistake or whatever reason it is trying the case. Okay, in such case, writ of prohibition may be issued, wherein higher court will order the lower court that you need to stop this proceeding because you don't have jurisdiction, or maybe because you are not following the principles of natural justice which should be followed. Principles of natural justice are nothing but these three things that we need to follow. Both the sides should be heard before giving a decision. No one should judge their own case, and reasoned decision. Okay, so if a lower court is going beyond their jurisdiction or taking up a matter where they don't have jurisdiction, or somehow there is some mistake, something happening, higher courts will issue the writ of prohibition and ask the lower court to stop that proceeding because maybe they don't have jurisdiction over there. Okay, this is nothing but writ of prohibition. But it may happen that by the time higher court comes to know that this certain matter is tried by a court not having jurisdiction, it may happen that lower court has already given a decision also. Lower court even passed an order also, right? In such cases, what will happen is higher court will certify or be informed. Higher court will quash that order. Higher court would say that no, this certain order which was passed by lower court, this is not valid. This was not properly decided. Maybe they did not take into consideration the evidences, this, that. Okay, so in such cases, we will call it certiorari, to be certified or be informed. Higher court would say, does not matter, even if lower court has already given a decision, that decision is not binding. Why? Because it was wrongfully decided. They were not having jurisdiction only, but still they decided the case. So this certain order, this certain decision is not binding. It is not valid. Okay, take for example, an incident took place in Bangalore and only courts in Bangalore was having jurisdiction. But parties filed the case in Punjab and Punjab court even tried the matter, gave a decision. Okay, so in such a case, certiorari will be issued wherein court would say that no, this is not the right court to try this matter. Then we have Q warranto, which means by what authority. All right. Like another common thing is show cause notice. What is show cause notice? Heard of it? Show cause notice?
Don't know.
Show cause notice is something, okay, wherein maybe some departmental proceeding or something, there is a possibility, all right, might be like within a department, someone has complained against another person, all right, so department will give a chance to the other person, okay, department will say that so and so thing has happened, this person has complained, now show cause notice will be issued, as in department will say that show us reason or show us causes why we should not be taking action against you, okay, as if the person is given time to give any defense that he might be having. This is nothing but show cause, all right. Now this is somewhat similar to Q warranto. What happens is court would ask by what authority, okay, sometimes you will see that maybe it is legality of a claim of a public officer. Take for example, there is one post, just an example, okay, maybe in passport office there is a post, passport officer, all right, and for this post graduation degree is mandatory, okay, and someone has seen that the person who is holding this position, passport officer, he is not having a post graduation degree, he is just having an undergraduation degree. So if he files a case in the court would ask him that show us reasons, right, that by what authority you are holding this position, because for this position post graduation is mandatory. So in that case, the person might say that, okay, there is some special rules or regulations wherein maybe by way of sports quota, if you are applying, you under graduation degree is also fine. All right. So these would nothing but Q warranto. Same ways, take for example, there is a department wherein only director is having the power to issue notifications, maybe regarding vacancies and so many other things. Only director, it has to be undersigned by director. Director can issue notifications. But a certain notification is issued wherein assistant director is the one undersigned. Assistant director is the one who is undersigned. Their court may ask by what authority you have issued this notification, because for this department only director is having the authority. Okay, so this is nothing but Q warranto. The person can justify what reason, by what reason he is holding a certain public office, or he has taken a certain step, or maybe a decision, or maybe some action he has taken. Okay, so these are the 5 different writs by way of which fundamental rights may be enforced. Habeas corpus, to have the body. If someone is wrongfully arrested, wrongfully denied, court may ask, bring this person in front of us, let us see if the ground of arrest are proper or not. If not, court may even ask to release the person. Same ways we have mandamus, which means to command. If there is a public duty, public officer is having a duty, he is not following the duty, in such case mandamus may be filed, wherein court would ask, this is your public duty, you need to perform it. So you do your duty. Prohibition, if a lower court or a subordinate court is deciding a matter by going beyond its jurisdiction, higher court may ask it to stop. If the proceeding is still going on, higher court will ask that you stop. You don't have jurisdiction to try this matter. But if the matter is already been decided by lower court, by the time higher court passes a decision, it would be certiorari. Higher court would say this decision was not properly, this case was not properly decided, this decision will not be valid or binding. That is certiorari. Q warranto, by what authority? By what authority you are holding this public position, or by what authority you have taken this certain step. Okay, is it clear?
Yes, ma'am.